Welcome to our guidance video on the importance of your checklist regarding your trust. Let's review. Starting in the top left of the checklist, you will see 2 rows and 4 columns designated to you and your spouses. If applicable, basic information. This includes your names, dates of birth, phone number, and email address. Row 5 to 10 in columns B and C is where you and your spouse will be adding your beneficiaries for your trust. Section B will be for your beneficiaries, and Section C will be for your spouse's beneficiaries. Adding beneficiaries to a trust is crucial because it ensures that the assets held in the trust are distributed according to your wishes. Here are some key reasons why adding beneficiaries is important. 1. Defines who receives the assets. The primary purpose of a trust is to pass on wealth, property, or assets to specific individuals or organizations. Naming beneficiaries clarifies who will inherit these assets. 2. Avoids probate. Unlike a will, assets in a trust do not go through probate, allowing beneficiaries to receive their inheritance faster and with fewer legal hurdles. 3. Ensures financial security. A trust allows you to provide for loved ones, especially minors, elderly family members, or individuals with special needs, ensuring their long-term financial well-being. Moving on to row 12, you will see a section that asks for your homeowner's insurance agent name and company name. Keep in mind that we will contact your insurance agent for you to make sure that all T's are crossed and I's are dotted. Knowing your homeowner's insurance agent and company is important when setting up a trust because you're ensuring proper coverage. When you transfer your home into a trust, the title of the property changes to the name of the trust. Some insurance companies may require policy updates to reflect this change and ensure continuous coverage. Avoiding coverage lapses. If your insurance company is unaware of the trust, they might deny claims or even cancel your policy, leaving your home unprotected. Coordinating liability. Protection. Depending on how your trust is structured, you may need to update your liability coverage to reflect the new ownership arrangement properly. Mortgage and lender requirements. If you have a mortgage, your lender may have specific insurance requirements when transferring property into a trust. Your insurance agent can help navigate this process. Aligning beneficiary designations. If your trust is designed to pass assets to specific beneficiaries, ensuring that your insurance policy aligns with these intentions can prevent disputes and complications. By working closely with your insurance agent and company, you can avoid potential issues and ensure that your home remains fully protected under your trust. Moving on to row 15, you will see where it begins a checklist for your asset types, companies those assets are through, the account or item amounts, and beneficiaries for each kind of asset that you have. You will see rows 16 through 33 list the most common asset types, these being checking account, savings account, investment accounts, mutual funds, CD, annuities, vehicles, 401k, TSP, 403b, IRA, Roth IRA, precious metals, and some other sections for any other kinds of assets that you might have. Adding your assets and naming beneficiaries in your trust is crucial for several reasons. Avoids probate. Assets properly titled in the trust bypass the costly and time-consuming probate process, allowing for a smoother transfer to beneficiaries. Ensures control. You dictate how and when assets are distributed, providing structure for beneficiaries, e.g., minors, special needs individuals, or those with financial difficulties. Protects privacy. Unlike a will, a trust is private, keeping your financial affairs out of public records. Reduces estate taxes. Certain types of trusts can help minimize estate taxes, preserving more wealth for your heirs. Prevents legal disputes. A well-structured trust reduces the likelihood of family conflicts over inheritance. Provides for incapacity. If you become incapacitated, a successor trustee can manage your assets without court intervention. Covers all assets. Simply creating a trust isn't enough. Funding it, retitling assets into the trust, ensures your estate plan works as intended. By ensuring your trust is properly funded with assets and designated beneficiaries, you maximize its benefits and protect your legacy efficiently. Once you complete your assets section, you will move on to row 40, where there are some important things for you to think about regarding your trust. These will need to be thought about by both you and your spouse. Row 41 starts the first question with, who do you want for executor of your estate? Appointing an executor for your estate in relation to your trust is crucial for ensuring that your assets are properly managed and distributed according to your wishes. Here's why it's important. 1. Ensures smooth administration. The executor, also called a trustee if handling a trust, takes responsibility for managing your estate and ensuring that all assets are distributed as outlined in the trust. 2. Avoids delays and disputes. Without a designated executor, there may be legal battles or confusion about who should handle the trust, leading to unnecessary delays and conflicts among beneficiaries. 3. Manages financial and legal obligations. The executor ensures that all debts, taxes, and administrative expenses are paid before distributing assets, preventing legal or financial issues. The next row, row 42, asks who you want for your payable on death regarding your checking account. Adding a payable on death, POD, designation to your checking account is important when it comes to your trust because it helps ensure a smooth transfer of funds upon your passing. Here's why it matters. 1. Avoids probate. A POD account bypasses probate, meaning the funds go directly to the named beneficiary instead of being tied up in court proceedings. 2. Ensures immediate access. Your trust or named individual beneficiary can access the money immediately upon your death, which can be useful for paying estate expenses, taxes, or other obligations. 3. Maintains privacy. Unlike probate, which is a public process, a POD designation keeps your financial details private. 4. Aligns with your estate plan. If your trust is the beneficiary of the POD account, it ensures that the funds are distributed according to your trust instructions rather than defaulting to probate rules. 5. Flexibility and control. You can change or revoke the POD beneficiary at any time without needing to update your trust documents. On to the next row down, row 43, it asks for a POD regarding your savings account. The importance of this aligns with the previous information about a POD for your checking account. Row 44 asks who you and your spouse would like to be your primary power of attorney, financial. Adding a primary power of attorney, financial, to your trust is an essential step in ensuring that your financial affairs are properly managed in case of incapacity. Here's why it's important. 1. Ensures financial continuity. If you become incapacitated due to illness, injury, or aging, your designated financial power of attorney, POA, can step in to handle your financial matters, ensuring bills are paid, investments are managed, and assets are protected. 2. Avoids court-appointed guardianship. Without a power of attorney, your family may have to go through a lengthy and expensive court process to appoint a guardian or conservator to manage your finances. 3. Works alongside your trust. A trust typically controls only the assets you place into it. A financial POA can manage assets that may not be in the trust, such as retirement accounts, personal bank accounts, or newly acquired assets that haven't yet been transferred into the trust. 4. Prevents delays in decision-making. A POA allows an agent to act immediately, avoiding delays that could arise if court intervention is required. 5. Flexibility in financial transactions. The POA can handle important financial matters, such as signing contracts, filing taxes, managing real estate, and making investment decisions on your behalf. 6. Protects against fraud and exploitation. By appointing a trusted individual as your financial power of attorney, you reduce the risk of financial exploitation, as your agent has a legal obligation to act in your best interest. 7th, customized authority. You can specify the powers granted to your agent, including limitations, to ensure they only manage what's necessary. Key takeaway. While a trust is crucial for estate planning, a primary financial power of attorney ensures that your financial matters are handled efficiently during your lifetime, particularly if you become incapacitated. Together, they create a comprehensive financial protection plan. Next row down, row 45, asks for a secondary financial power of attorney for you and your spouse. Importance of a secondary successor financial power of attorney. A secondary or successor power of attorney financial acts as a backup if your primary power of attorney is unable or unwilling to serve. Here's why having a secondary POA is crucial. 1. Ensures continuity in financial management. If your primary agent becomes incapacitated, passes away, or declines to serve, the secondary POA can immediately step in to manage your financial affairs. This prevents disruptions in bill payments, asset management, and financial decision-making. 2. Avoids the need for court intervention. Without a secondary POA, if your primary agent cannot serve, your loved ones may have to go through a legal process to appoint a guardian or conservator. Having a designated successor simplifies transitions and avoids unnecessary legal battles. Row 46 asks for a primary power of attorney, medical, for you and your spouse. A primary power of attorney, medical, is crucial in the context of a trust because it ensures that someone can make healthcare decisions on behalf of the trust grantor, the person who created the trust, if they become incapacitated. Here's why it matters. 1. Ensures continuity of trust management. A trust primarily deals with financial and asset-related matters, but if the grantor becomes incapacitated, they may also need medical decisions made on their behalf. The trustee may not have authority over medical decisions unless explicitly granted in the trust document. 2. Prevents court intervention, guardianship, conservatorship. Without a medical power of attorney, loved ones may need to go through a court process to obtain guardianship or conservatorship to make medical decisions. This process can be costly, time-consuming, and emotionally stressful. 3. Aligns medical care with estate planning goals. The medical power of attorney, POA, ensures that healthcare decisions align with the grantor's wishes, which can be crucial if the trust includes provisions for long-term care, Medicaid planning, or special needs planning. 4. Avoids conflicts between trustees and family. If the trustee is managing assets for the grantor's benefit but has no authority over medical decisions, disputes may arise between family members and financial managers. The medical POA clarifies roles and responsibilities, preventing potential legal and personal conflicts. 5. Facilitates payment of medical expenses. While the trustee can use trust assets to pay medical expenses, they may need to coordinate with the medical POA to ensure funds are available for necessary treatments or long-term care. How it works with a trust. The medical POA typically works alongside a financial power of attorney or successor trustee to ensure seamless decision-making. The grantor should ensure that both the medical POA and financial POA trustee are aware of each other's roles and responsibilities. Key takeaway. Having a primary medical power of attorney ensures that medical decisions are made according to the grantor's wishes, avoids legal complications, and allows for smooth coordination between healthcare and financial management, particularly when a trust is in place. Row 47 asks you and your spouse to designate a secondary power of attorney, medical, a secondary or successor. Medical power of attorney is just as important as the primary, especially in the context of a trust. Here's why having a backup is crucial. 1. Ensures decision-making continuity. If the primary medical power of attorney is unable or unwilling to serve due to illness, death, unavailability, or personal reasons, the secondary POA steps in immediately. This prevents delays in crucial medical decisions, ensuring that healthcare and long-term care decisions remain aligned with the trust grantor's wishes. 2. Prevents court involvement. Without a secondary POA, if the primary is unavailable, family members may need to petition the court for a guardian or healthcare proxy. This process can be time-consuming and expensive and may lead to decisions that do not align with the grantor's estate and trust plans. 3. Avoids conflicts between the trustee and family. If medical decisions impact the financial management of a trust, e.g., long-term care, medical expenses, assisted living, having a clear chain of authority for medical decisions ensures coordination with the trustee or financial power of attorney. This minimizes potential conflicts among family members or between the medical and financial decision-makers. 4. Provides flexibility in long-term planning. If the grantor has a trust that includes provisions for medical care, disability, or Medicaid planning, a secondary medical POA ensures that there is always someone available to advocate for their medical preferences. This is especially important in elder care or special needs planning within a trust. 5. Protects against unforeseen circumstances. Life is unpredictable. Someone designated as the primary POA may decline the responsibility, become incapacitated, or even move far away. A secondary medical POA ensures that there is always a trusted individual ready to step in. How it works with a trust. The trust grantor appoints a primary and secondary medical power of attorney in their healthcare directive or advance directive. The trustee or successor trustee should be aware of these designations to ensure medical and financial decisions align, particularly if the trust is funding healthcare needs. Key takeaway. A secondary medical power of attorney acts as an essential backup, ensuring uninterrupted decision-making, preventing legal disputes, and maintaining coordination with the trust's financial management. Every well-structured estate plan should include both a primary and a secondary medical POA for comprehensive protection. Next up is Row 48, which asks you and your spouse if you would like your children to receive assets in equal amounts. You might want all of your assets distributed equally to your children through a trust in situations where fairness and equality. You want to ensure that each child receives the same amount to avoid potential conflicts or feelings of favoritism. No unique financial needs. None of your children have special financial circumstances that would require unequal distributions, such as disabilities, debts, or differing levels of financial stability. Avoiding family disputes. If you believe equal distribution will minimize potential disagreements or legal battles between siblings. Preserving family harmony. You want to promote unity and prevent resentment among your children. All children have similar relationships with you. There are no significant differences in your relationships that might justify an unequal distribution. No special contributions by any child. None of your children provided extraordinary care, financial assistance, or contributions to your estate that would warrant an unequal share. Estate size is large enough. If your estate is substantial, an equal split may ensure each child receives a meaningful inheritance without financial strain. Your children have similar financial stability. No child requires a greater share due to financial hardship or life circumstances. Simplicity in estate planning. Equal division is straightforward and can simplify the administration of the trust, avoiding favoritism and potential legal challenges. Unequal distributions can sometimes lead to legal disputes, so an equal split can reduce the likelihood of contests. Now, in row 49, you have the option to either have your assets from the trust go to your children up front or spread out after a certain age. Whether you distribute trust assets to your children immediately or spread them out over time depends on various factors, including financial responsibility, maturity, and long-term goals. Here are some common situations for both approaches. 1. Distributing assets upfront, lump sum or full access at a certain age. You may choose to give your children their full inheritance immediately if they are financially responsible. Your children have demonstrated good money management skills and won't squander the inheritance. They are adults with stable careers. If they are already well established, a lump sum could be beneficial for investments or major life purchases. The estate is small or moderate. If the inheritance isn't large enough to require long-term management, an outright distribution may be simpler. You trust their judgment. If your children are mature enough to handle wealth responsibly, there's less need for restrictions. They have an immediate need. They may need funds for education, home purchases, business ventures, or paying off debts. You want to avoid ongoing trust administration costs. Trusts require management fees, and outright distribution eliminates these expenses. Second, spreading out the inheritance, staggered or conditional distributions. You might want to delay or structure the distribution over time. If your children are young, minors or young adults might not have the life experience to handle a large sum responsibly. You want to encourage financial responsibility. Releasing funds in stages, e.g. at ages 25, 30, 35, can prevent reckless spending. You want to protect against poor financial decisions. If a child has a history of bad spending, addiction, or financial instability, spreading payments reduces risk. To provide long-term security, a structured distribution ensures your children have financial support throughout their lives. Concerns about divorce or lawsuits. If your child gets divorced or is sued, assets held in a trust are often more protected. Business or investment goals. Gradual payments can be tied to financial goals, such as funding education, starting a business, or home ownership. Special needs or disabilities. A special needs trust can ensure long-term financial support without jeopardizing government benefits. The second to last row, row 50, says that distributions can be different depending on your child's needs, and to list all children and what ages you will want them to receive assets. The final row, row 51, asks you and your spouse to think about if you have any pets, who you would want to be the beneficiary of them if something were to happen to you. Please note that when we begin to build your trust, you will want all of this information figured out and filled out. If you have any questions, feel free to reach out before by email or during our appointment. Thank you so much for watching, and congrats on taking the steps to secure you and your family's future.